I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Before we get into our agenda, I just have a few housekeeping announcements. As you know, we are here as guests of the First District Court of Appeal, and we're thankful that they allow us to use these beautiful facilities, so we want to respect their rules, and one of them is for all people, including commissioners, nothing other than water, no food or beverage is allowed in the courtroom. And please remember to silence your cell phones. We keep accurate voice recordings, and we ask that anyone who speaks, whether commissioners or people from the audience, please speak up so our recording equipment can pick you up, and speak into the microphone so it can be heard. Members, I would ask you to be as brief and concise as you can, as we have a number of items for consideration today, and we want to honor everybody's time. Pursuant to Section 286-0114 of the Florida statutes, members of the public in this public session will have the opportunity to have input on matters before the commission other than cases in which we act in a quasi-judicial capacity. This means the public can have input on matters other than complaints, opinions, and determinations in financial disclosure cases. If you desire to be heard, please fill out a speaker card and give it to Mrs. Fulford, who is seated in the back of the courtroom, who is waving at everybody. That having been said, we'll move to the first item on the agenda, and that is the approval of the minutes, which have been circulated and have been meticulously read by all of us. So I will entertain a motion to adopt the minutes unless somebody has a motion to amend the minutes.
Move to adopt.
Second.
Commissioner Gates, Commissioner Ankers, all in favor?
Aye.
Say aye. All opposed, like sign. The first item is consideration of final action on pre-probable cause stipulation. This is complaint number 22-006, Mary Beth Henderson. We have before us a proposed pre-probable cause stipulation between the commission advocate and the respondent. This matter is being considered in a public session because in signing and filling pre-probable cause stipulation, they have waived confidentiality. After considering the materials and the presentation of the parties, the commission can vote to approve or reject stipulation. As this is a pre-probable cause stipulation, if the stipulation is rejected, we will go immediately into a probable cause hearing on this complaint. The parties cannot renegotiate and present a new stipulation at this meeting. Complainants have the right to comment in writing on proposed stipulations. We have not received any comment from the complainant in this matter. Ms. Hadley is the advocate. Is the complainant or anyone else here? Mr. Herron?
Mark Herron on behalf of Mary Beth Henderson.
Thank you. Is anyone else here on any reason?
I understood that Ms. Henderson would be here, but we can go ahead. I'm sure she'll be okay.
Okay, all right, fine. Ms. Hadley, you are recognized to present the stipulation.
At this time, I bring before you a pre-probable cause stipulation. Respondent acknowledged that she failed to accurately file her 2017 and 2018 CE Form 1s regarding reportable interest in violation of Section 112.3145. Please note that it is Section 112.3145 as there is a scrivener's error in paragraphs 11 and 12. Respondent has filed an amended form for the relevant years to rectify the matter. We ask the Commission to accept the respondent's stipulation that she violated the Code of Ethics and recommend a total civil penalty of $750. We ask for the commission to dismiss the 2016 allegation as the evidence does not reflect a violation.
Are there questions of respondent from members, or the respondent want to make a presentation?
Mr. Chairman, members of the commission, Mark Herron on behalf of Mary Beth Henderson. We would ask that you adopt the advocate's suggestion that you approve the joint stipulation. As you know, the Form 1 is a very complicated form. As you members have to fill them out yourself, there's a lot of math involved, and Mr. Henderson was the one that actually filled out these forms on behalf of his wife. They have very extensive holdings, and he did not understand the instructions completely. And again, I would ask that you adopt the joint stipulation.
Are there questions of the respondents, counsel, from members of the commission? Is there a motion on adoption of the stipulation?
So moved.
Second.
Commissioner Wallman, Commissioner Ankers, is there discussion? All in favor, say aye.
Aye.
Opposed, like sign. Okay. The next one is consideration of final action on pre-probable cause stipulation. It is in Ray Celso Alfonso, number 22 -009. Ms. Hadley, you are here as the advocate. Is anyone here for the respondent? All right, Ms. Hadley, you're recognized.
At this time, I bring before you a pre-probable cause stipulation. Respondent acknowledged that he failed to accurately file a 2019 CE Form 6 in violation of Article 2, Section 8 Florida Constitution, and Section 112.3.144. Respondent failed to disclose a $1,600 bank account which exceeded the $1,000 disclosure threshold. The respondent has filed an amended form to correct the issue. We ask the commission to accept the respondent's stipulation that he violated the Code of Ethics and recommend a total civil penalty of $250.
Are there questions of the advocate? Is there a motion on adoption of the stipulation?
Move the approval of the proposed joint stipulation.
Second. Commissioner Ankers and Commissioner Jerome? Okay, is there any discussion? All in favor, say aye.
Aye.
All opposed, like sign. Show it adopted. Move to the next item, 6A, consideration of final action, amended stipulation, and rescinding of final order.
We still have
I'm
Mr.
sorry?
Merritt, Randall Merritt. The next one.
Oh, wait a minute, I skipped over one, didn't I? Yeah, I'm sorry. Randall Merritt, 20-120. Mr. Herron, you represent,
Mark Herron on behalf of Randall Merritt.
okay, and Ms.
Mr.
Hadley?
Merritt is here today as well.
Okay, thank you, sir. Ms. Hadley?
Respondent serves as a member of the Wakulla County Commission. The commission found probable cause to believe that he violated Section 112.3.143.3 and Article 2, Section 8 Florida Constitution and Section 112.3.144 of the Florida statutes. Through settlement discussions, the parties have come to an agreement. In the stipulation, respondent admits that he violated the Code of Ethics regarding his CE Form 6 and agrees to the entry of a final order recommending a civil penalty of $1,000 with public censure and reprimand. Regarding the other allegation, the parties agreed that a reading of the opinion in the email provided by commission staff regarding respondent's ability to vote on the subject may have created ambiguity in the manner in which respondent voted on an October 3rd, 2016 measure. As such, we ask for the allegation regarding Section 112.3.143.3 be dismissed. We respectfully ask for the commission's approval of the joint stipulation.
Mr. Herron, you're recognized.
Mr. Chairman, I join with the advocate in asking that the commission adopt the joint stipulation.
Are there questions of either party? Commissioner Carvajal?
I think my question might be as much a statement as a question. So when we are denying allegation 1, would an advisory opinion be a good idea to avoid future conflicts in such a manner? Because we haven't settled the question, right? We're just agreeing that in this negotiation, we're not going to pursue allegation one.
I'm going to direct that question regarding advisory opinion to the general counsel.
Through the chair, an advisory opinion is the deliverable that that the commission would issue upon request by a requester. In this particular matter, that it hasn't been requested. The other thing about an advisory opinion is it advises future conduct. All of this conduct seems to be well in the past, so we wouldn't issue an advisory opinion for the conduct at issue here.
May I follow up, sir?
Please.
Then, how would we treat if any additional work happens under the same situation? Because what we're doing is currently denying allegation one, but that doesn't mean that another case can't be filed in this case. Any suggestions for us on the commission?
If the commission dismisses, and please correct me if I'm wrong, if the commission dismisses allegation one, then that matter can no longer be brought because it's dismissed, that particular allegation regarding the October 3rd, 2016 voting measure.
May I help assist perhaps Commissioner Carvajal? It's very doubtful that this will repeat itself in the sense that Commissioner Merritt is leaving the commission in November.
Further questions? Do I hear a motion on adoption?
Who will adopt?
Commissioner Meigs,
Second.
Commissioner Carvajal. Is there discussion from members of the commission? All in favor, say aye.
Aye.
Opposed, like sign. The next one is Omar Hardy, 20-165 and 20-184, that have together been consolidated. Will the parties identify themselves?
Commissioner, I will be making a brief presentation on this because this matter is a little non-standard.
Okay. Okay. Is anyone else here on the case?
No.
Okay. Mr. Zulikowski, you're recognized.
Thank you, Mr. Chair. Commissioners, as you know, sometimes you are presented with stipulated agreements between the advocate and the respondents. Those agreements contain stipulated findings of fact, stipulated conclusions of law, and a stipulated penalty. When you vote to adopt the stipulation, your legal staff drafts a final order to that effect, and your staff issues that final order to memorialize the vote. At the last commission meeting in July, you adopted a joint stipulation between the advocate and the respondent in this matter, Mr. Omari Hardy. The party stipulated to a violation of Section 112.3144 and Article 2, Section 8 to show that there was a inaccurate filing of a Form 6 financial disclosure form. The agreed penalty was a civil penalty of $1,000 and a public censure and reprimand. The original stipulation contained a term indicating that the commission would refer the matter to the Speaker of the House for the imposition of the penalty. It is appropriate to refer the imposition of an ethics penalty to the Speaker when the respondent in the matter is when the respondent who is being penalized is a current member of the House of Representatives or the violation occurred when they were a member of the House. Upon further review, we determined that the proper referral in this matter would be to the governor, not to the Speaker. And that is because the violation occurred while the respondent was a candidate to become a member of the House, and the penalty is being imposed at a point when he is no longer a member of the House. He had resigned his office as a member of the House on January 10th, 2021. To alleviate any confusion, and the parties have made an amended stipulation, and the amended stipulation does not indicate that the matter will be referred to the Speaker. In actuality, we will refer this matter to the governor. The penalty in the amended stipulation is identical to the original stipulation that you approved last July. For these reasons, staff recommends that you will adopt the amended joint stipulation and the draft final order that rescinds the prior final order that came as a result of the previous vote. If you don't have any questions, then I can turn the matter over to the advocates to explain the joint stip.
All right. Questions of members of the commission? This is basically correcting the Scrivener's error for all practical purposes.
Yes.
Both have presented my whole argument, and we ask for the commission to accept the amended joint stipulation.
All right. Thank you. Great argument. Do I hear a motion for adoption of the amended stipulation?
So moved.
Second. All in favor, say aye.
Aye.
All opposed, like sign. All right, that takes us to the next item, 21-133, which is the case of Sherry McDonald. Ms. Miller is the advocate. Is there anyone else here? Mr. Herron?
Mark Heron on behalf of Sherry McDonald, and Ms. McDonald is here as well this morning.
Thank you for coming, Ms. McDonald, and welcome. Ms. Miller, you're recognized.
Good morning, Commissioners. Elizabeth Miller, advocate for the commission. This is the second time I've come before you requesting that the complaint be dismissed, but it is the first written motion that I have filed in that regard. As you'll recall, the respondent in this case served many or multiple positions with the town of Yankeetown. She was the town clerk, administrator clerk to the special master judge, and she was the public records custodian. The town council voted to amend her contract so that she could work a few more years, and they voted unanimously on that. The mayor told the respondent to rewrite her contract to reflect that, and she did. And as you'll recall, the amendment was pretty messed up, quite frankly. What she had done was she had significantly written the addendum or rewritten the contract by cutting and pasting, and it turned out to provide her with many more benefits than she was originally due under the original contract. The crux of this case is whether her actions were corrupt, whether she misused her position with a corrupt intent. There is not sufficient evidence to infer that her actions were corrupt. Her work was sloppy, it was amateurish, it was fraught with errors, and it was not up to an acceptable standard. It was a lot of things, but I don't believe that it was corrupt, and I don't believe that the evidence shows it was. As you'll see, attached to my motion are all the written comments from the members who served on the council at the time. And please let me point out that this town is very small. At the time, their attorney was not involved in the addendum because of the expense. However, after this, he did rewrite her employment contract, and then she resigned. Thank you. I would ask you to dismiss the complaint. Thank you very much.
Thank you, Ms. Miller. Mr. Herron.
On behalf of Ms. McDonald, we would join in the advocate's motion to dismiss. You will see from the advocate went forward following the finding of probable cause. She talked to all the pertinent witnesses in the case. Their statements and comments are attached to her motion. I believe that they definitely show that there was no corrupt intent. This was just an accident through cut and pasting that resulted in this, and we would ask that we would join in the motion to dismiss the complaint.
Thank you, Mr. Herron. Now, just so you'll understand, Commissioners, where we are, if you adopt the recommendation to dismiss, the case goes away. If you do not, then it goes to the Division of Administrative Hearings for a trial or an opportunity for the parties to enter into some settlement agreement. So do I hear a motion on the advocate's recommendation that it be dismissed?
Mr. Chairman, or will you take discussion after the motion?
Yes.
So moved.
Seconded.
Commissioner Wallman, Commissioner Carvajal. All right. Commissioner Gates, you're recognized.
Thank you, Mr. Chairman. You know, this was a case which the commission sent back to the advocate when we had initially a request that the matter be dismissed. And speaking only for myself, but recalling the discussion that we had, the commission, I think, recognized that this was, you know, not a huge matter involving a great deal of money, but that it was a case of someone in a public position basically appearing to feather their nest in an improper and unethical manner. And I appreciate the work that's been done. I know it's taken a good bit of time on the part of the advocate to go back and talk to the witnesses and get the information that's before us. And I'm certainly prepared to support the motion. But I would point out, Mr. Chairman, that in the motion that we're being asked to approve, you know, there are a couple of statements that I think we need to just bear in mind. One is, it is true that this is a small community with 600 people. And we tend to sort of say, well, in a small community where, one person has to do a lot of jobs, there can be blurring of boundaries and lines and who should do what to whom when, and there are costs associated with asking the town attorney to opine in a matter or advise in a matter. But I think it does raise the question, if this very same activity, if this very same case were brought to us from a community not of 600 people, but 6,000 or 60,000 or 600,000, where would be the borderland between right and wrong in a case like this? Secondly, and I quote from the proposed motion, mistakes can be explained away by a claim of ineptitude and incompetence and the lack of attention, end quote, and the lack of attention by elected officials who should oversee this matter. Again, I would say that it raises a question. We can explain away, as is being suggested here, these actions by ineptitude and incompetence and the lack of attention. And it's a small amount of money in the grand scheme of things. But if it were the larger amount of money with a larger community, how would we feel? So the caution flag I would raise for my colleagues is, as we approve this motion to dismiss, bear in mind that there may be times in the future when someone will refer back to this case and will remind us that incompetence and ineptitude and lack of attention by public officials has been used by this commission as a reason not to go forward. I realize that corrupt intent is the rock upon which a case that would go forward to the administrative law judge, that's the rock upon which this could perish. I guess I would just ask this question, and I'm not making a motion, but at the very least, should we not have done a reprimand or a censure? At the very least, should we not have done something other than to dismiss, but to rather indicate the view of this commission that the activities in this case by this respondent were unethical. If we don't, I'll sleep well at night. If we do, I'd sleep a little better at night. But I would just point out that I think of this matter, this may be quoted to us in the future, and we should bear that in mind. Thank you, Mr. Chairman, for your indulgence.
Thank you, Commissioner Gates, and you're authorized to sleep through the rest of this meeting.
And you would appreciate it if I did.
No, and let me just make a comment. I think Commissioner Gates has certainly hit on something that has always concerned me in my 3 terms on this commission. And that is, we kind of have a one-size-fits-all law, and there is a different kind of service between being on the Sop-Choppy Fire District and being a commissioner in a big city, or being a member of the legislature, or being a highly elected official, or a state attorney. There's a distinction, obviously, from a practical standpoint, but the law doesn't make that distinction. If you are elected, appointed, et cetera, you have to file these forms. And You know, I once served on the board of a public corporation, and the Congress adopted Sarbanes-Oxley. We only had 300 stockholders. And Sarbanes-Oxley came along. We ended up dissolving the company because it cost all of our annual profits just to comply with the law that was adopted not to affect little corporations like us, but big corporations. But one size fit all, and we had to deal accordingly. And Commissioner Gates, I don't have a solution, and maybe that's a legislative matter, but I think you have certainly, I mean, we just, you know, we have here a case, and we've had a couple of others where they're small cities, small districts, they don't have an attorney, they don't have administrators, they don't have people to assist them in filing the forms. And as someone said earlier, I think you, Mr. Herrick, that Form 1, it's fairly complicated. You know, it involves some mathematical calculations, and you know, if you don't understand it and there's nowhere to turn, you can make mistakes. And then we end up punishing you because you make a mistake. So that's not a suggestion or a motion either, obviously. It's my response to what Commissioner Gates has raised, and I think it's a very valid point. Mr. Savarni, Commissioner Savarni.
Mr. Chair, first I need to note that Yankeetown was within my jurisdiction when I was state attorney in the Eighth Circuit. I do not know these parties or this incident at all, so I have no problem with participating. I will add, though, and kind of in response to what Commissioner Gates is saying, I have got to overlay the lack of sophistication that I know exists in, just like you're saying, very small municipalities like this. Was not at all unique to Yankeetown. It probably exists in every tiny municipality across the state. And with that context, I have to agree that this is an appropriate result.
Thank you. Commissioner Meigs.
I just have a question. Did anybody read the contract? As I looked at the stuff, I don't remember finding that anybody even read it. The commissioners all said they signed it, or the mayor said they signed it. Am I right, wrong?
If I may,
Can't
through the
remember.
chair, yes, sir, you're absolutely correct. And the mayor took responsibility. He said he should have read it. But it was adopted by the board without anybody proofreading it or looking it over.
Chairman. Commissioner Moore.
In reading through this, this is obviously my first time reading through all these documents, but what struck me, and I understand the excuse of a lack of a level of sophistication, but they can hire sophistication. And it seems to me that the fault here lies with that town council in trying to save $1. They have spent a lot more money of the public's money and having to come here to a hearing and doing everything else that's been involved with this case. I agree with Commissioner Gates that, you know, I'm concerned that we are sending a message that says, well, you know, if you bumble, it's okay, when there really is no excuse to bumble. You can get back up, you can hire an attorney. God forbid that I'm advocating hiring attorneys. There is competent advice out there, and this group decided to not avail themselves of that competent advice, and that bothers me greatly.
Commissioner Andrews.
Prior to Commissioner Gates' question, I just had a procedural one, maybe the general counsel can help me with. When we have previously dismissed matters, I can't recall whether we've had an order that said anything other than this matter's dismissed, or do we ever add any context for that dismissal? I didn't see a proposed dismissal with this one, and part of the reason I asked is it may be an opportunity to add some context for the dismissal that reflects the comments that you've heard.
Normally, the final order would just say that the matter was dismissed as a result of the motion. There's not a lot of context that would be put into the final order, but if it was the will of the commission, I'm sure, you know, it's your final order. We could add something, but typically we wouldn't, once the matter goes public, there is a report of investigation, the whole case file becomes public. So the entire history, including the audio of this discussion, which is happening in a public session, all of that would be a matter of public record and open to inspection.
This is a tiny, tiny detail, but in the event that we do have any fleshing out, so to speak, of the context in the dismissal, I would want to make sure that we just clarify the spelling of counsel and counsel, because it's been used twice in the motion, and it's relevant in this case whether the contract was submitted to the town council as in the lawyer versus the town council as in the body. So it just, if we do have any further discussion about it, I want to make sure we confirm that.
Thank you. Commissioner Gilzine.
Thank you. If the commission rejects the advocate's motion, what posture will we be in, and what are our options to do after?
Through the chair, if the motion to dismiss this matter is rejected, then the posture of it is you've already issued a probable cause finding, so the matter would eventually be queued up to go to DOA at the urging of when the advocate is ready to bring it.
Are there further questions? Commissioner Carvajal.
Not a question, but for comment. Thank you, sir. While I absolutely respect all the comments that have been made and agree that sometimes we have to overlay templates to analyze capacity, we should never shrink the expectation of trust that the public is expecting in this process. And I don't think we did. I mean, many of us acknowledge that this was probably an error. The advocate actually almost begged us last time not to allow it to go forward because she is not likely to get a favorable, she did not say this in any way, but we are not likely to get something at the end of DOA that suggests that there was intent in this. But I think that our actions up to date have pointed out that we don't think that the size of a community changes the expectations that we have for trust, just an understanding of the levels of how we execute things. I'll support the motion to dismiss in large part because I'm not sure she will get a greater censure than the one she just got here, but if there is a motion or any additions, I'll also support any additional notions, because if it does come back, we want to point out that it does not matter what size your community is, the trust is trust and cannot be shrunk in any way by this commission.
All right, Commissioners, we've had a number of questions and a number of comments. We have before us a motion, and I will certainly allow any commissioners to speak for or against adoption of the motion. It also would be appropriate if someone wants to make an amendment to the motion, and we would discuss that. So the floor is open for any comments for or against or change that any member of the commission may have. All right, none appearing? All in favor of adopting the recommendation, say aye. 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 All opposed, like sign.
Aye.
Show it adopted. Ms. McDonald, thank you for your service and thank you for being here. All right, that takes us to the next item, which is consideration of an advisory opinion. People in various positions have the ability, when there is doubt in their mind as to what may or may not be appropriate, they have a standing to come before the commission and ask for an advisory opinion. I actually did that myself one time when I was serving in public office, and I had a real question as to what was appropriate. And I filed a request, and I got an answer. And so that's what's before us now in file number 2790. Kathy, you are recognized to present the draft opinion.
Thank you, Mr. Chair. And I'd like to inform you that Mr. Berry is not he's not present today. Commissioners, this opinion request has been brought by a commissioner for the North Broward Hospital District. The district is considering issuing a bid solicitation for a new vendor for its electronic health records database. The electronic health records database houses the medical records for the district. In his request, the commissioner posed 6 questions, which have been rephrased as 3 questions in the draft opinion, 1 for each of the legal issues raised. The first question in the draft opinion pertains to whether there would be a conflict of interest under section 112.313(7A) Florida statutes if the requester participated in discussions and decision-making regarding the selection of a health records database provider for the district. The second question in the draft opinion pertains to whether there would be a voting conflict under section 112.313 Florida statutes if he participated and voted on the selection of the electronic records database provider at the district meetings. The third question in the draft opinion pertains to whether there would be a misuse under section 112.3136 Florida statutes if the requester were to express his opinion regarding the selection of a database provider on district stationery, to district staff, or verbally within the community, as long as he makes it clear that he's expressing his personal opinion and not the opinion of the board. For sake of background, the requester's father-in-law was diagnosed with a serious ailment for which he was treated at a non-district hospital. Non-district hospitals and district hospitals use different electronic records databases. When the requester's father later transferred to a district hospital, his health records were not transferred. The requester believes that the reason the records were not transferred is because the electronic health records databases at the two hospitals do not communicate well with each other. The requester believes that the fact that the records were not transferred led to his father-in-law's receiving inferior treatment at the district hospital. He thus has an interest in ensuring that the health records databases utilized at district hospitals are able to communicate and interact with health records databases of other non-district hospitals. The requester states that he told district personnel, somewhat hyperbolically, that he would not sue the district if it found a way for the electronic health records databases to utilized by the non-district hospitals to communicate and integrate with the district hospitals' databases. But both he and the district agree that this informal and unwritten promise would not be legally enforceable. The requester also owns a company that assists hospitals when they change from one electronic health records database to another. His company closes out the records in the databases that are no longer going to be used. It is hospitals and not the vendors, not the database vendors, that they would be the requester's clients in these situations. His company has no contractual or financial relationships with any electronic health records database vendors, and he has not had any contractual or financial relationships with any of them in the past. If district hospitals were to change to a different health records database system, the commissioner states that neither he nor his company would be financially affected. Now, there are 2 wrinkles in the facts that appear to complicate matters, but which actually do not present a conflict of interest. The first wrinkle is the requester's mention of a lawsuit, and the second is that his business is sometimes employed to wind down existing electronic health records databases when hospitals change databases. Regarding the first question in the draft opinion of whether the commissioner would have a conflict of interest under section 112.3137A if he participated in discussions and decision-making regarding the selection of a health records provider, section 112.3137A contains several prohibitions. The first prohibition, found in the first clause of 7A, provides that a public officer, such as the requester, cannot have any employment or contractual relationship with a business that does business with his agency, which would be the district. Under the facts provided, the Commissioner's business would not create a conflict under Section 112-3137A because neither he nor his business have a contractual relationship with the district or with any of the electronic health records database providers. In addition, since his statement to district personnel that he would not sue the district if it ensured that its electronic health records database would be able to communicate with those used by non-district hospitals, that was unenforceable. Okay, I'm sorry, since that was unenforceable, the requester does not have a contractual relationship with the district in terms of any lawsuit. In light of this, the draft opinion advises that the requester would not have a conflict of interest if he were to participate in discussions or decision-making during board meetings regarding the selection of electronic health records database provider. The second question in the draft opinion addresses whether the requester would have a voting conflict under Section 112.3143 Florida statutes if he participated in discussions regarding the selection of an electronic health records database provider in district board meetings and if he voted on the matter. In order for there to be a voting conflict, whatever the requester voted on would have to inure to his special private gain or loss, and this would have to be an economic benefit or harm. It would have to, the vote would have to inure to the gain or loss of a principal by whom the commissioner was retained, or a principal of a subsidiary of his business, one of his relatives, or any business associate he might have. None of the facts indicate that the requester's voting on this matter would result in a special private gain or loss for any of these parties or entities. Therefore, the draft opinion advises that the commissioner would not have a voting conflict if he participated in discussions and voted on the selection of an electronic database provider at board meetings. The requester's third question pertains to whether he would be abusing or misusing his position if he expressed his opinion concerning the selection of the database provider on district stationery, to district staff, or verbally within the community if he made it clear that he was speaking in his own private opinion and not in the voice of the board. The requester did not say what he would be writing or saying, to whom he would be writing or speaking, and what possible benefit he might receive from doing this. As a result, it would be impossible to determine whether his proposed actions would be a misuse of his position. As such, we have declined to answer the question because it's wholly hypothetical. I now offer the draft for your consideration, and I'd be happy to answer any questions.
Thank you for the presentation. Are there questions? Commissioner Wallman.
Thank you, Mr. Chair. It actually seems like to me his threat of litigation, he's actually winning, and so he is getting a special benefit here by threatening that I'm going to sue if you don't do this. If you do it, then I won't. So he's getting something that he shouldn't be getting. It's almost like a settlement, and he's winning.
Through the chair, there are several databases that are mentioned in the materials. One the commissioner would prefer, okay, this is what these are anticipated to be in the bid selection. One of these the commissioner would prefer. One he would not prefer because that's the one that the district uses now. So the fact that there's a bid solicitation does not mean that he would get his way.
Commissioner Wallman.
And I understand, I get all of that he doesn't have a specific interest in any one of the databases or the vendors that's going to be chosen. However, it seems to me, he's made a threat to his body that he's on and says, if you don't do this, then I'm going to sue you. And that's it. I don't think any of us should be able to be in a position as a commissioner, or in this instance, a commissioner as well, that we threaten, if you don't do this, I'm gonna sue you.
Through the chair.
Mr. Zolakowski, you're recognized.
Thank you. You know, Kathy's doing a really great job here on her first formal opinion here, and, you know, she's been with us for just 2.5 months, so she's doing a great job. But I just want to jump in on one quick thing about that. The posture that we're in, we're issuing guidance on a going forward basis to let him know how he can maintain compliance with the Code of Ethics. The facts state that in the past, he made a threat against his agency, or, you know, if you want to call it a threat, or he made some sort of what he's calling a hyperbolic statement. The fact remains that that's past conduct. There isn't anything that we can do to advise him on a going forward basis what to do and what not to do. He is potentially, you know, as any individual is with their past conduct, open to a complaint. But as far as the posture that we're in right now, there isn't really anything for us to do on that statement. He is asking us, hey, if I use some stationery or if I do some other things, will that be a misuse of my position? And we've declined to answer that because of how vague the question really is, and that the context for doing that matters. So the whole angle here on whether or not he's done a misuse in the past, we're not going to answer that because that's past conduct. Whether or not he might do a misuse in the future, we're not answering that because it's very hypothetical, very vague question for which we are lacking in details, and we're unable to give a blanket yes or a blanket no. And so that's kind of the landscape on the misuse area.
Just a follow-up. And I preface all this by saying I agree with your position in this. What you're proposing to us, I think, is correct. Mine's more of a statement. I think it's very bad when a public official, a commissioner on a commission says, if you don't do this, I'm going to sue. I mean, but that's a separate complaint. And to my knowledge, nobody's made that complaint yet. But that to me is an abuse of your position. So that being said, I agree, and it was an excellent presentation.
Are there further questions? Commissioner Carvajal?
I think I had the same thought as I was reading the opinion. I agree with the opinion. This was one of the stipulations, and I understand, but you used a term in your explanation through the chair just a second ago that is different than the request. These requests are about conflicts of interest, and I think we answered those questions properly, but a footnote talking about the misuse of by one making certain comments and sitting on the board is not in the opinion, and we have often done some advisements that said, you know, you may have a personal interest, but don't forget that oftentimes you're seen in that chair, and misuse might arise. I think that's what you were trying to get at question 3, if I'm not mistaken, in your response, that you can't discuss. There's no answer to the conflict of interest because it's all hypothetical, but the misuse question, particularly that was just raised by Commissioner Waldman, is a little less than hypothetical, since past actions would suggest that there may be future interest, personal interest in the lawsuit, which I don't know if it's open or closed and doesn't matter to me.
Just to clarify on the vocabulary, question 1 is the conflict of interest question. Kathy does answer that. Question 2 is the voting conflict question, and in the draft that Kathy wrote, Kathy answers that. It's question 3 on the misuse that we declined because it's hypothetical, and we don't even touch the past conduct part of it. So just to be clear, we are not punting on the conflict of interest. That does get answered.
Mr. Chairman.
Commissioner Gates?
Thank you, Mr. Chairman. But I believe Representative Waldman raises a very good point in the sense that, hyperbolic or not, when one serves in a public capacity and threatens a lawsuit against another public entity, albeit for you know, reasons that probably were understandable, because you had a relative who felt like were mistreated for the lack of good coordination of data between two competing hospital systems. When that kind of threat is made, it's in the environment, it's in the air. It can't be unsaid, and it can't be explained away by saying, I was just being hyperbolic. Good Lord, I could explain away 94% of my public career that way. If I were allowed to, but I'm not. I have to.
Second that motion.
Because people know me too well. But I think that Representative Waldman makes a good point in the sense that a threat of a lawsuit was made, and now we have a series of actions that have occurred. Now, were all those actions caused by a threat of a lawsuit? No, I don't think so. But the fact is that, that the arguments could certainly be made that he's getting his way, as Commissioner Waldman said. And therefore, I would urge a footnote in some fashion that would reflect the inappropriateness of and obviously you'll use the appropriate language, of a person in public office making a threat like that, and placing that threat in the environment of decisions made by public boards. And I want to commend counsel for this opinion, because I know a little something about the healthcare system, having spent about 25 years in it, and I can tell you that you've really threaded the needle here because of the sort of interlocking way that people who deal with data, patient data, and deal with changing the systems that account for patient data, how that all works, and who would have a conflict of interest and who wouldn't. And I think everything that you've written, is correct. If I were this individual who's asked for this opinion, and this is, gets to the whole thing about the appearance as opposed to the technicalities, I probably wouldn't be talking about it, and I probably wouldn't be voting. I think it'd be a smart thing to do to avoid, more things in the environment. But I want to commend you on what I consider to be a well-written and also well-thought-out answer to a very complex question, given all of the interlocking relationships of this individual's business, how that business it relates to the facts of the case, and then the whole business of these, as Representative Waldman knows well, people familiar with South Florida, the hospital systems and their relationships with each other. So, well done, but I would urge a footnote.
Commissioner Meggs.
Maybe a point of clarification, as I read this, I don't see a threat to sue. I think he said, I will not sue. I don't see that as being a threat to sue. If I read it correctly, I don't know. I believe that's what I read. He said, I will not sue if we can straighten this mess up.
Yes, sir. Yes, sir, if we can
Well,
get.
that's not a threat to sue. That's just a statement that I want this mess straightened up. I don't see a real big deal with it about the suing. I just don't see it as a threat. So I'm gonna vote for if somebody makes a motion, I'm gonna vote for this opinion.
Further comments or questions?
Just following up on that, to me, it seems as if I have a cudgel in my hand and tell you I'm not going to hit you with it. I would perceive that to be a threat. Being new here, I don't know if someone should file a complaint on this issue. Have we had people come before this group with the "I was just kidding" defense? It seems that this is how it appears to me. Very well done, well read. I fully understood the issues, but just kidding to me doesn't carry much, and it does show intent. So I'm somewhat bothered by it. I agree with you, Chairman, Mr. President, that sometimes the better decision is to stay out of an issue and declare that you might potentially have a conflict. Perception does become reality in those cases. I'm bothered by this behavior.
Ms. Stillman, you're recognized.
Just a note regarding complaints versus opinion requests and how that has worked. Yes, in the past, occasionally someone who has requested an opinion later does see a complaint filed against them surrounding a similar or same course of conduct. As staff, we can't encourage or discourage the filing of a complaint. But I will note that when people do seek opinions, formal opinions from this body that are in the public and not hidden from the public, they are seeking to be transparent and to comply with the law in the future, notwithstanding how messy the facts might be. I wouldn't presume to know someone's motivations, but I do know that when people contact us, they are seeking our assistance. And so whatever guidance you decide you would like in a footnote, I'm sure that the legal team will be happy to put that in there.
Thank you for that clarification. Okay, the chair is open to receiving a motion on the advisory opinion as presented.
Mr. Chairman, I move that the advisory opinion be approved with the request that council insert a footnote memorializing the conversation that the commission had on this matter.
Second.
Okay, Commissioner Gates, Commissioner Moore, is there discussion? All in favor, say aye.
Aye.
Opposed, like sign. Show it adopted. Thank you for a good presentation.
Thank you very much.
Okay, Mr. Schaefer, you are recognized. We have a second order on request for extension. I granted the first one, and apparently the situation that caused us to extend one time has unfortunately not gone away. Mr. Schaefer, you're recognized.
Thank you, Chair. This is, as you said, a request for a second extension on the filing of, I believe it's a Form 1. The requester is a member of the Madison County Planning and Zoning Board. We received notification early August that he had been hospitalized with a serious ailment, and he was not expected to be released from the hospital for 3 months. Because of that, the Chair found there was good cause to grant an initial 45-day extension on filing his Form 1 financial disclosure. That initial extension ran to and including October 17th. And because this individual is not expected to be released from the hospital until it would be early to mid-November, he's probably going to need some additional time. And so because it's beyond the initial 45-day window that the Chair can grant on his own, that's why I'm bringing this back before you all to approve a second extension, giving him until the end of the year to file his Form 1. That'll be about a month and a half after he's released from the hospital. So I would ask that you approve this request for a second extension.
Questions? Commissioner Waldman.
Not a question, but I think there's a typo in the order. It says October 17, 2021. I think that should be 2022.
Yes, thank you for pointing that out. I would make sure that any final order reflects that.
But I support the request.
Commissioner Carvajal.
Thank you, Chair. Just to clarify, while we're extending this, he is also not acting in his public role. He's not appearing or passing rules through the Planning and Zoning Board while he's hospitalized.
Through the Chair, I'm not aware of the answer to that question. The information received just indicates that he is in the hospital and that it is serious.
When it's appropriate for discussion, all I'll say is I approve, obviously, the extension, but if somebody is being extended for financial disclosure at the same time that they are also potentially voting on issues, the reason that the financial disclosures exist at all is so people know the transparency. But I think we'll give him the benefit of the doubt, particularly since he's in the hospital.
Okay. Further questions or comments? Is there a motion?
So moved.
Second.
Commissioner Waldman, Commissioner Carvajal, all in favor say aye.
Aye.
All opposed, like sign. Mr. Schaefer, don't go away. That takes us to the next item, which is consideration of rulemaking. We have a request for an extension. I'm sorry, got the wrong one. Anyway, we have the ability to change rules, and the purpose is to allow the commission to hear public comment, have evidence, argument about the proposed rules change, and following the public hearing, and this is the public hearing, the commission can decide whether or not to make any changes. And so I'll ask Mr. Schaefer, who prepared the draft item, to explain the changes, to put us in the proper posture, and then we'll proceed with a public hearing if there are any persons here who desire to make public input, and then we will take action on the request. Mr. Schaefer, you're recognized.
Thank you, Chair. This is a rulemaking matter here. It is fairly straightforward, though. Commissioners, this particular rule amendment, these changes all pertain to Rule 34-8 of the Florida Administrative Code. That rule, among other things, sets out and incorporates by reference the Commission's various financial disclosure forms, as well as the instructions that are required to complete those forms. And as the Chair said, each year you review the forms and the instructions and you approve proposed amendments prepared by staff to update or clarify them, and that's why we're here this morning. And if you remember from last year, we updated our rules concerning switching the Form 6 to electronic filing. We kind of had to overhaul those rules. And next year, when we start preparing for electronic filing of Form 1s, we'll likely have to update our Form 1 rules to reflect electronic filing as well. But for today, the proposed amendment before you is much more straightforward. And because we have no other substantive changes that need to be addressed, right now at least, the only amendments are going to be to update the forms and instructions to reflect the appropriate calendar year. So all we're proposing doing here this morning is updating the years on the forms. That would mean the Form 1 and the instructions for the Form 6 need to be updated to reflect the filing year of 2022, and the Form 1F and the instructions for the Form 6F need to be updated to reflect the filing year of 2023. These changes were all duly noticed. In August, we published a notice of proposed rulemaking in the Florida Administrative Register. We haven't received any comments on that through the Register's website. We did submit these proposed amendments to JAPSI, which is the Rules Committee that has to review all potential rules. They have not issued any feedback to us either, so I would take it to mean that they are not in disagreement with updating these dates. So if you decide to approve the changes today, the only step remaining in the rulemaking process is going to be to submit these changes for adoption to the Department of State. I would ask this morning that you do approve updating just the years on the forms. That's all that we're here for. So they'll be ready to go in January 1st of next year when these forms and instructions take effect.
All right, thank you, Mr. Schaefer, for that presentation. We'll now move into the public hearing. Are there any persons in the audience who desire to make any input or comments on this particular rule change? None appearing, and Mr. Schaefer has done an excellent job of summing up where we are, so I don't think he needs to say anything more. Is there a motion to adopt, reject, or change the proposed rule?
I move we adopt the proposed rule updates.
Second.
Commissioner Ankers, Commissioner Cervone, discussion.
Just a question, actually. In what we have, there's underlined in regarding shellfish handling, and I don't understand. Is that new? It's the first part. It's the first part of this, and what you have there. So it says
The shellfish matter.
shellfish handling.
Comes.
I have no idea, but is this changing the rule for that?
If I might, Chair.
Ms. Dillon.
That's on page 2 of your packet, and that just relates to a different rule that happens to be just where we are placed in the publication. We're not doing anything related to.
We're not getting in the oyster business?
Just trying to understand it, but okay. I support the motion's been made. I support the motion.
And you've always supported the shellfish.
I support the shellfish. I enjoy it.
We just are pleased to know that you've done your homework, Commissioner Walden.
Got it.
You've read the materials. Are there further comments? Commissioner Carvajal.
Thank you, Mr. Chairman. Maybe it's a statement, and I obviously support the motion as well, but in other instances when we're updating the rules, we more directly highlight the changes either through strike and replace and or color highlight it. And at least the version that I have doesn't have that, so I want to make sure that it, a recommendation for future, let's just make sure that we can see the changes. The benefit to the public as well as those of us who are reading the shellfish sections of the Administrative Register.
Okay, further comments? All right, the motion is before us. All in favor, say aye.
Aye.
Opposed, like sign. Show it adopted. Thank you, Mr. Schaefer. The next item is a consideration of 2023 legislative recommendations. As you know, the Florida legislature is like a boomerang. It keeps coming back every year. And we keep making recommendations, and sometimes those boomerang back to us because legislature said they don't want to do it that way. And we had a little bit of difficulty during the last session, and we got some and we didn't get others, and a lot of the concern revolved around e-filing. But I have been working closely with the executive director. We spent almost an hour on the phone yesterday talking about it, trying to get a handle on what's going to happen. And of course, this is an election year, so we don't have a sliced idea of who will chair committees, and in some cases, even who will get elected. But we're trying to get our act put together, and Ms. Tillman did an excellent job at our last meeting presenting some proposed legislative changes. It's my proposal that right after the organizational session, she and I will sit down with the speaker and the president, if they will grant us an audience, and say this is what we would like to do, and can you give us some guidance, and we'll move forward from there. We have a later session this year or this coming year than we had in 2022, so that gives us a little bit more time to find sponsors and see if the chairman of the respective committees want to make it a committee bill, or who's going to carry the water, and so forth. I think our recommendations are reasonable, and I'm going to turn it over to Carrie to kind of briefly go through what she went through at our last meeting, because certainly we welcome the input of any members of the commission. This is certainly not my recommendation, it's not Carrie's recommendation, it's going to be the commission's recommendation. So we invite input, and we want to make sure that when we get ready to walk down the street to the Capitol, that we're able to speak for the entire commission. So, Ms. Tillman, you're recognized.
Okay, thank you, Mr. Chair. I will be brief in going over these. I know we went through them at the last meeting for the benefit of the new members, make sure that everyone is on the same page with what we're looking at. These are the recommendations that you made last year to the legislature, none of which passed. Many of them have been on our list for a number of years. Starting with the conflict of interest, it has to do with the example of if a city councilman cannot contract with business B, if business B is doing business with the city. But if the councilman creates A Incorporated, that corporation can do business with business B without violating the law, even if A Incorporated is solely owned by Councilman A. So the commission has said in the past this thwarts the underlying goal of the statute, which is to prevent these officials from having prohibited business relationships and contractual relationships with companies that do business with their agencies. There was nothing that I'm aware of that hit in 2022 in relation to this, but in 2021 there was a bill that had some related language. So there's been a little bit of it out there, but it's not gotten full traction. When it comes to voting conflicts law, you all have recommended that the voting conflict law should be the same for everyone, whether they are appointed, elected, whether they are at the state level or at the local level, to reduce confusions. So we have had some traction related to the local voting conflict law, making the elected officials' requirements the same as the appointed officials. It's not gotten traction in relation to state-appointed and elected voting conflict changes, but we have had some traction with that even in 2022. The big one that got a lot of attention last year was the enhanced financial disclosure. That was where your recommendation was for elected city commissioners and mayors to file the Form 6 disclosure form. as county commissioners do, as school board members do, members of the legislature, other constitutional officers. We did have a bill in the House and the Senate related to this that did not have a fluctuating standard. In other words, your recommendation has been regardless of revenue or population, these city officials should be filing the Form 6. We had it, and then we didn't. But the sponsor in the House, Representative Roach, is interested in helping us out again this year with sponsoring if that's the way we want to go. So hopefully we can move forward with that. You've also recommended dismissal of complaints alleging a de minimis financial disclosure violation. Currently in 112.324 sub 11, that is not allowed, and so you've asked for the ability to do that when you find that the public interest would not be served. For similarly, the dismissal of lobbyist audit firm matters, which has been the subject of much consternation of this commission when we've considered those complaints. Currently, you're not able to dismiss a lobbyist audit firm matter, even when the circumstances might justify a dismissal when the public interest would not be served. So you've asked for that change. There was language in a bill last year related to that. It did not pass the legislature at that time. Significantly, you've talked repeatedly about increasing civil penalties. That's long been on the list. It went off for a little while and came back on. I did not find any legislation last year related to this item, but you have asked that the legislature consider that due to inflation and the fact that the civil penalty amounts have not been increased since 1994, it's currently capped at a maximum of $10,000 per violation, that they consider giving you all room by increasing the maximum fine. Whistleblower-like protection for ethics complainants. I think it's been commented that maybe we don't need more quantity of ethics complaints, but we might need better quality of ethics complaints at times, and there might be individuals who have knowledge of matters happening that might fall under the jurisdiction of this commission and result in a violation, but there's no real protection for folks who file an ethics complaint, and you're seeking for some sort of protections or remedies akin to the Whistleblowers Act to apply to ethics complaints. There was no legislation on this last year. There was a glitch item related to training where officials who assume a new term of office on or after March 31 are not required to file or to take the training for that year, the 4 hours of training. CRA members were added to that training requirement. However, due to the way it was drafted, they were not included in the language relating to that exemption. So if they're elected in November, they've got to get it done by the end of December. So we've asked that that glitch item be corrected. Finally, there have been a couple of matters that have come up in past sessions. I didn't see them this last year relating to representing clients before their own board. The commission has consistently said that if a person serves on a board, he or she cannot represent clients before that board, and neither can members of their professional firm. Similar to the rules of professional conduct for the Florida Bar, it imputes a conflict of one lawyer to all lawyers in the firm. The commission has viewed that as an important protection and has opposed very strongly any relaxation to that standard. I haven't seen anything on it, but if you care to renew that opposition to that, that helps when it starts to rear its head in the waning days of session, as it sometimes had. Similarly, gifts, expenditures, and compensation from lobbyists. There was a bill that made some good headway in 2020 session. The bills that did not pass would have allowed donations from lobbyists or principals unlimited in amount to certain public employees and appointed officials if the donations were used towards costs associated with serious disease, injury, or illness of the appointed employee, or excuse me, the employee, the appointed officer, or their child. That vast exemption to the gift and expenditure laws, aimed at public officials when they're most vulnerable to undue influence from special interests, the commission has said would undermine the effective restrictions and prohibitions that have long stood, and so the commission has opposed that standard. Of course, there's always e-filing that exists. We're currently working towards the relaunch of the Form 6 in light of feedback and legislation that was filed last session. We will have to address the timing of the launch of the Form 1s due to the language in the implementing bill to ensure that that happens no sooner than Jan 1, 2024. And what that best date would be, we're still figuring out. And I know you'll support us once the electronic filing team figures out what that date is, and I'll certainly be reporting back on that.
Thank you for that excellent report. Are there questions or comments from members of the commission? You may not have any today, but as we move forward, we have one more meeting before the election. That is our October 21st, I think, meeting. And, you know, we hope that we can get this pretty well refined by that time. So if not today, certainly before then, contact me, contact Carrie, and make your input so that we can move forward in a consolidated effort. Are there questions? Commissioner Waldman.
Thank you, Mr. Chair. Just a comment, and I support the agenda that you have here, but I know we've talked about it before regarding increasing civil penalties. However, it is very rare that we even hit that cap that we have now. And if we're looking for more, we ought to have a reason why we want more money or the ability to issue greater civil penalties, and we just don't have it. You know, today, just a $250 fine or $500, we're not even getting close, and we ought to, I think, as a commission, maybe discuss implementing higher fines and decide if those are appropriate, because realistically, I mean, I think a $250 fine is not anything more than just a slap on the wrist. And maybe that's just me. I mean, I know $250 is a lot of money to some people, but I think there's got to be some real teeth to what we do. And I don't see a $250 fine as teeth.
Yeah, that's been a concern, Commissioner Waldman. You've raised it. I think Commissioner Gates raised it. You know, we had a situation a meeting or two ago where, you know, I think all of us felt that what was imposed was totally inappropriate given the circumstances of the case, and so I would certainly concur with your comments. Are there further questions?
Mr. Chairman?
Yeah, Commissioner Gates.
Thank you. I want to associate myself with Commissioner Waldman's comments in this matter. We actually lost some steam on getting the penalty ceiling raised when I had some conversations with Senate leadership last year, and I was forced to have to answer the question, how often are you hitting the ceiling now? And, you know, we had to give an honest answer, and the answer was, well, come back when your head's hurting because you're hitting the ceiling too often. And I thought that was not an unsympathetic and not an inappropriate response to our request. So if we believe that that penalties for ethical violations are too low, then perhaps we ought to act that way. The second thing I would say is that I agree with everything that our executive director has laid out and our chair has laid out. But I think, as all of us know, if you do have the opportunity to get something done on an ethics bill, and you know, those who are leading the effort to have higher ethical standards in Tallahassee are not met by a lot of heavy traffic. They don't have any, you know, traffic problems on that highway. It's pretty empty. If you get that opportunity, obviously sometimes you have to say, here's what's most important. So I would simply agree with everything you've said, but would want the commission to give our chair and our executive director the total flexibility in the moment to say, well, if we can't have all that, can we have this? And to make some priorities. Now, you know, I trust the chair based on, and our executive director entirely, based on the conversations we've had and will have as to these matters, that they can draw those distinctions and speak for us. But I would want to make sure on the record that I'm giving full support to our chair and executive director to get what they can get when they can get it, and to establish priorities in the moment.
Thank you. All right.
Do you want to vote on these as officially what we're going to put
Sure.
forward?
Yeah, the executive director suggested that we might want to have a vote so that, and if we do a vote, and I think we should, it is always subject to review. If we come back in the next meeting or the following meeting and it's come to our knowledge for various reasons that we need to make a change, then we certainly have the ability to do that. But I think that she's made a great suggestion, and so I will entertain a motion that we adopt what she has just outlined as our legislative agenda for the year 2023.
So moved.
Commissioner Gilzine? Is there a second?
Second.
Commissioner Cervone, all in favor, say aye.
Aye.
All opposed, like sign. Thank you. Commissioner Carvajal.
Mr. Chair, a question related to delegation of authority. I think in the past, we've had an implicit that the chair and the executive director are the representatives. Does the executive director believe that she needs anything more than that as a statement?
I don't believe at this time, if that is the will of the commission, that is what we can go with. I will note that in January, we will be selecting a new chair and new vice chair, because Chair Grant's one-year term will be up. Of course, as with last year, any one of you can help in the efforts downtown, and I hope that you will. What I can't do is get you all together and we all go up there due to the sunshine law. We can't do that without a notice public meeting, but I hope that you will all take an active role in contacting those who you know and helping us. And I know you were very, very helpful last year with the work that we were doing.
Mr. Chair?
Commissioner Gates.
I would just say, given the fact that we have a 9-member commission, that I would recommend that the better part of valor is that all of us have friends and contacts that could be useful in supporting this agenda. But for myself, I won't make a contact about this agenda with any member of the legislature without first clearing it with the executive director or the chair. Because, you know, those conversations lead to questions like, well, what about this instead of that? Well, then suddenly I'm speaking as a commission member, and you know, I don't want there to be any crossed wires. It's hard enough to get an ethics bill passed or an ethics provision passed in any case. So I will always defer to the chair and the executive director, and if they agree that I should speak to someone, then I'll do it. Otherwise, I'll wait for their direction.
Further comments? All right, that takes us to the final item on the agenda, reports. The first one is the report of the chair. I have just one item to bring up, and that is to note that today is a milestone day because it represents the one-year anniversary of Carrie Stillman being our executive director. So the chair is open to a motion that we retain her for an additional year.
I didn't know this was a one-year renewable.
I'll go for 3 months.
In all seriousness, I just can't tell you how much I have personally appreciated the opportunity to work with Carrie. She has done an excellent job in making a lot of changes in our commission. We're running better now than we've ever been running. We have an excellent staff, but Carrie is there as the leader of all of them. And on my own behalf, and I think I speak for the commission, I just want to express my appreciation for Carrie and her service and all that she has done and all that she continues to do. And we wish her well going into the next year. I did have a talk with her yesterday, and she told me that she actually, a couple of weeks ago, put a rug down in her office and started putting things on the wall, and one of her staff members said, well, I guess you're going to stay. And we're delighted she's going to stay. So, Carrie, my appreciation and congratulations. And any of the other commissioners want to say anything, that's fine. And that concludes my report. So, Carrie, see if you can do one better than that.
Well, I'll try. I just wanted to point out in the executive director's report, you'll see a very long list of litigation. This is the heaviest litigation load I can recall that our legal team and our agency has had since I've been reading these executive director's reports as filed by others. They have been working really, really hard on your behalf with this litigation, together with the advocates working on these cases as well. But I just want to point out that that's sort of the posture that we're in, and we're monitoring that with the general counsel almost daily, talking about these cases and trying to work through them and get, hopefully very soon have fewer of them as opposed to more. Staff news and notes, I wanted to welcome Alexa Ravencroft as our fall intern. She's our fall legal intern. She's in her second year of law school at the Florida State University. She joined us in August, and she assists our legal team with legal research and writing, and we're very happy to have her with us, so please welcome her. Also, Buff and Melody have a new employee. Please join me in welcoming paralegal Rakisha Everett to the legal team. I know they're overjoyed. I think they haven't had a paralegal since last December, so we welcome you with open arms, and we look forward to working with you in the coming weeks, months, and years. News from our staff, September 1 brought us a couple of promotions. Keith Powell, who's a senior investigator, he was promoted to the position of investigations manager. And this is a new thing for our office. Although our investigative team is our largest team, we really didn't have someone functioning in that role. And Keith is ideal. I think after only 35 years of experience, he might have something to offer in this regard. And we've been working with him through the transition. And as Bob was leaving, to make sure that we had a good sense of where we were with our caseload. He'll be helping to manage caseload. He'll be working fewer cases. Traditionally, he's worked a lot of our more complex cases. He will be backing off of that and working more with training and quality control and review of investigations, and helping to keep us efficient with our numbers and timeframes of investigations. Similarly, Ron Moali was promoted to senior investigator effective September 1. Ron has been with us since, I believe, 2003, and in my estimation, this promotion was long overdue. He's a skilled and experienced ethics investigator. Our investigations are very unique in the way they're written up and the way we go about them. He's demonstrated consistency and productivity, and it's been an example to all of our staff. He's committed to our mission, and he'll be a great leader on our investigations team. And finally, wanted to give you an update on the financial disclosure compliance rates for this year, and we've had a good one. For state-level Form 1 filers, there have been 12,821 Form 1s filed. Only 102 Form 1s are outstanding. So our compliance rate sits at 99.2% of filers filing prior to getting fined. With it being queued off of a postmark, there's still a chance a few more could straggle in, but we're going to sit at better than 99% for this year. That makes us very happy. For Form 6 non-judicial filers, We've had 1,374 filed with the commission. There are 6 outstanding, compliance rate of 99.6%. So we did all of our required statutory obligations in terms of noticing. We also had our staff phone fun day where we all make phone calls. We made hundreds and hundreds of calls and emails and begged and pleaded and encouraged filers to get them in, and those efforts have paid off, and that is all that I have for you today.
All right, are there any questions of our executive director? Thank you for that report. Okay, it is now 3 minutes past when our executive session was to begin, and we need to get the room set up for that. So why don't we come back at 10:30? That'll give us about almost 25 minutes and a chance to take a little break.
That's a long time.
That's a long time.
You want to shorten that a little bit?
Can we shorten that?
Let's make it 10:15.
Oh, now we get it.
All right. We'll make it 10:15 and Commissioner Savon moves his eyes.